Hi, in this video we're going to talk about the guardianship process in detail. In other words, we're going to show you step by step what you should expect when you are confronted with a guardianship situation. From the beginning, I just want to make again some concepts that I talk and discuss about in my videos, and I want to emphasize because they are very, very important. And number one, there is a presumption of capacity in Florida. In other words, the only person that can take away your capacity is the judge. There is no process done by a doctor with a letter, or a financial advisor, or an attorney. So there is a presumption of capacity even though you are in a coma with Alzheimer's, dementia, or any other condition that affects you mentally, and it is obvious that you lack capacity. So the only person that can take away your capacity is a judge, following this process of determination of incapacity that we're going to talk about. While you go through that process of determination of incapacity, the legal term used by everyone in the court is that the person supposedly to be incapacitated is the alleged incapacitated person, or AIP. That's a term that is a term that is defined in the statutes. So they're still not is still not considered incapacitated. It's just alleged incapacitated person. And the third one is that not because you have a familial relationship with someone that entitles you to make decision for that person. So let's say your husband is diagnosed with Alzheimer's or dementia, doesn't mean that you as the wife can make decision for that person. So there got to be a document that says that you are appointed. If you were not appointed a representative, an agent, or a surrogate, or whatever, then you have to go through this process of guardianship. So again, your familial relationship with someone doesn't entitle you to make decisions. It's either you have to get your documents done, like powers of attorney, healthcare surrogate, or you have to go through this guardianship process. So those are the things that we're gonna discuss more in detail in the next video. Hi, in this video, we are gonna discuss more in detail the guardianship process. So this is what you should expect when someone tells you, hey, you need to do a guardianship. So let's say you go to the bank, you go to the nursing home or assisted living facility, hospital, whatever it is that you encounter, and somebody tells you, or everyone is telling you, it's like a common theme, that you need guardianship over your loved ones. So basically, after everyone telling you that you need to start a guardianship process, you see an attorney, an elder law attorney, or a guardianship attorney, and basically they tell you, yes, you need to start a guardianship process. So in this part of the video, we're going to explain what that guardianship process looks like and what you should expect, because it's quite confusing for a lot of people, and people don't understand why we need to do a few things. And so we're going to try to clarify that. So the first thing is, when you see an attorney, you hire an attorney, and the first thing you need to understand is that whoever you hire, whoever is the person who hired the attorney, that person is called the petitioner. So let's say you are the wife, and your husband has been diagnosed with Alzheimer's or dementia, or is in a coma, or somehow you believe is incapacitated, and you need to do things for your husband. So you, the wife, are the petitioner. That's your legal term, or your legal role in this whole process. You, the wife, are the petitioner, and you, the wife, hire an attorney who is going to represent you, the wife. the attorney that you are hiring is not going to represent your husband. So that attorney will file a petition for determination of incapacity. So that's your step one. Your step one is when you hire that attorney will file a petition for determination of incapacity, and that petition will allege and will say that someone is mentally incapacitated. In this case, the wife is going to say the husband is mentally incapacitated, and these are the reasons why, and these are the reasons or the evidence that support that petition. So once you file the petition and the court accepts that, the court will appoint an attorney for the alleged incapacitated person. So that's your step number two. So here, the term for your husband will be alleged incapacitated person. Remember, or AIP. Remember that that person is still presumed to have capacity. So nobody ever, or the judge, no judge ever has declared incapacity for your husband. So therefore, that person is still presumed to have capacity, even though that person has been diagnosed with Alzheimer's or dementia, or is in a coma and completely incapacitated, and you believe that there's no brainer, that person is incapacitated. Why you would need to go through this process? Again, the law presumes that a person has capacity until a court, after following the due process of law, declares that that person is incapacitated. So what's the step number three? Step number three is the court will appoint a medical committee. So this medical committee is a committee composed of three people. One is a general practitioner, doctor, the other one is psychologist, and the third one is psychiatrist. And again, you ask, why do we need a committee of three doctors when I already have my family practitioner who already diagnosed my husband with dementia or Alzheimer's or coma or whatever? And the reason why is again, we need an independent body of professionals to examine the alleged incapacitated person. So those three people are appointed to do that job. So basically, they will conduct an examination and they will try to find the reports with the judge. So what's step number four? Step number four is the court-appointed attorney and the committee will meet with the alleged incapacitated person. So basically, here is these three committee members and the attorney will find a day and a time to meet with the alleged incapacitated person, in this case, your husband. And then even though your husband is not able to speak with them, they have to meet with your husband. They have to conduct an examination. They have to run tests, and they have to explain to the alleged incapacitated person that a guardianship has been filed or a petition for determination of incapacity has been filed, and that attorney will explain to the alleged incapacitated person that the court-appointed attorney represents the interest of the alleged incapacitated person. The attorney that was hired by the wife represents the interest of the wife and the family, if you wanna be a little bit more clear. But again, the point is that these are conflicting interests, and one attorney represents the petitioner and the other attorney represents the alleged incapacitated person. So again, all of them will meet and will run tests and conduct examinations and will also write recommendations to the court. Yes, this person is a guardian. Yes, we found that this person has Alzheimer's. Yes, we believe that it is better that a guardian be appointed and things like that. So step number five is the court-appointed attorney and the committee members will file reports with the court. So basically here what's going to happen is that after conducting the examination, the attorney that represents the alleged incapacitated person and the committee member will file their response or their report to the judge saying, yes, judge, this is what we found, and this is what we recommend. And the final step in this process is step number 6. The court will set a hearing date. And basically in this hearing date, everyone, the petitioner or the wife, the attorney who represents the petitioner, all the witness that the petitioner listed as witnesses will have to show up in court and testify. The examining committee members will have to testify. The the actual alleged incapacitated person can testify and can have preferences and things like that. So that person will also appear, or the attorney can say no, this person cannot appear at the hearing because is incapacitated and therefore cannot physically be here, and so therefore the attorney can what is called waive the presence of the alleged incapacitated person. So in that hearing day, after hearing all the evidence and all the evidence has been admitted, the court will make a decision. And that decision is basically whether that person, the alleged incapacitated person, is incapacitated or not. That's it. That's pretty much what the judge decides on that day. So, husband, yes, you are incapacitated, and for now on, all of your rights are removed, and we recommend that a guardian be appointed to exercise all of your rights. In other words, someone else will make decision for you. You cannot longer make decision for yourself. So basically, this is the process, and this is what you should expect when somebody tells you you need to do a guardianship. So the first step is the determination of incapacity. Without determination of incapacity, there cannot be a guardian appointed. So the first step is you file this petition. Again, the court appoints an attorney for the alleged incapacitated person. The court appoints a medical committee. They all meet with the alleged incapacitated person. The court appointed attorney and the committee file a report, and then finally everyone goes to in front of the judge, and the evidence is heard and admitted, and the judge then decides whether that person is incapacitated or not. This is the due process of law that must be followed in order for a guardian to be appointed for a person. Thank you very much. Hi, in this video, we are going to discuss in detail the guardianship process. And now we are at the point where the judge already declared the incapacity of a person, order that the person for now needs a guardian. So we now need to go through the process of appointment of a guardian. So first, what's going to happen first? Well, in real life, before I get into the steps, in real life, we already filed everything here. We already filed the petition for determination of incapacity, and with that, we also filed the petition for appointment of a guardian. So we already make those filings, and the court has in his possession all these documents. So we're just now going into what the judge is going to see now. So the first document that we need to have the court review is the appointment of a guardian. So basically, we file a petition by a family member, in this case, the wife, saying, Judge, I want to be the guardian of my husband. He has been declared incapacitated. I am qualified to be the guardian because I'm the spouse, and I want to start exercising my authority on his behalf. Once the petition is filed, then wife needs to go through a background investigation. So this is a background criminal investigation. Wife needs to go and get her fingerprints taken. That will be sent to the court by whoever is doing the fingerprints, and then wife needs to also file an application to become a guardian. In the application to become a guardian, wife needs to list her information, her basic information, name, social security, date of birth, employment history, criminal history, whether wife has been arrested or convicted of a felony. So the law doesn't want, or the law doesn't want convicted felons or people who abuse the elderly or any minor or any person to become guardians. So we need to go through that process, and we need to tell the judge whether we have any issues with the law in the past. In the application also, you need to list your employment history, your educational history, and your list of references. So naming the people who know you in the past 5 or 10 years. Once that is filed, you also need to file an oath, basically saying, hey, I'm committed to do this. I'm going to do the best job. I'm going to be diligent. I'm going to obey what the law says, and I will perform my duties according to the mandates of the law. Then, when everything is filed and correct, so there's no adverse background investigations, there's no issues, there is no, like, I don't know, background or let's say bankruptcy in your file. So everything is looks good in your application and background investigation. Then the judge will approve you as a guardian by issuing two important orders. This is something you always need to keep in mind and remember. From this point forward is that you become guardian. When the judge issued the order appointing you guardian, that's the order number one that you need to be aware of, and the letters of guardianship. These are the two documents that will allow you to do everything for the person who has been declared incapacitated. And by the way, that person now, the name of that person now is the ward. I forgot to mention that, but I would like to be clear that what we referred to before as the alleged incapacitated person now is a ward. The ward is the legal term that the statute refers to a person who has been declared incapacitated after following the due process of law. So again, going back to the orders, order appointing guardian and letters of guardianship. These are the documents that you need to submit to the banks, the hospital, the assisted living facility, the nursing home, and those are the documents that will allow you to do everything that you need to do for the person that has been declared incapacitated or is now the ward. Then you need to do a couple of more things. You need to take a course. In that course, the teacher will tell you what you need to do to fulfill your duties. So it's a course where they teach you your responsibilities, your duties, your obligations, everything that you can and you cannot do, and so on and so forth. So that course takes a whole day, so it's an 8-hour course, and you need to take it within a certain time of your orders appointed you guardian. And then the final step in this process is the reports. You need to file initial reports. One is for the personal or health related issues of the ward. So basically you're telling the court the ward is in this place, this is where he lives. These are the doctors that he will see. These are the frequencies of the appointments. This is the insurance that he has. These are the medication he's taking. These are the things that he can or cannot do. And so it's like a 5-page, 6-page report that you need to file initially when you are appointed guardian. And the other report that you need to file is the financial report, where you explain to the court the income, the income that the ward receives, and also the assets that that the ward has. So it has a house, bank statements, 401k, IRAs, investment properties, so on and so forth. So this is the initial steps. As for timing, what you should expect here, you should expect about 6 to 8 weeks from the moment that the petition for determination of incapacity is filed up to this moment is 6 to 8 weeks. In those 6 to 8 weeks is where the order is issued and these two course and reports are done. In terms of what can happen here, we can have any dispute occurring here. For example, here, the petition, anyone in the family can say, oh, I want to be the guardian. If there is a conflict, there is going to be litigation about who's going to be guardian, and that can take longer. Same thing in the initial petition for determination of incapacity. A family member may say, no, I don't think this person is incapacitated, and may contest that. So there can be a lot of issues and litigation that can delay the process and make it harder. So just bear that in mind. Also, cost. What you should expect in cost up to this point, I would say normally $20,000, $15,000 in that range, because remember that the attorney for the incapacitated or the alleged incapacitated person and now the ward is relieved from his or her duties at this point. So the attorney that was appointed by the court needs to be representing the alleged incapacitated person and the ward up to the point that you filed the report. So that person will bill you in addition to the attorney who you hired to do this job. So you should expect double fees. In addition, you have initial fees for the filing of the documents of the appointment, for the determination of incapacity. You also have court costs to pay the examining committee. You have court costs for filing the petition for appointment of a guardian. You have costs for doing the fingerprints. You have costs for submitting the application. You have costs for attending the course and for filing the reports. So you should expect about $15,000 to $20,000 in fees for the whole process. Now, compare this with a properly done power of attorney or healthcare surrogate. It may avoid the whole thing, and also a trust, doing a trust. So it may avoid this whole process because the judge is obligated to consider what is called alternatives to guardianship. So if you have properly executed powers of attorney, healthcare surrogate designation, and trust documents, you can avoid the whole process. Thank you very much, and I will see you in the next video.